Good afternoon. I'm the last voice that you're going to hear for the state. And we get the opportunity to speak to you last because we have the burden. And in this case, we have waited 27 years to get justice for us. And at this point, ladies and gentlemen, we have proved that this defendant killed Melissa Wolfenbarger sometime in late 1998 or early of March 1999 for no other reason except for jealousy, anger, and the fact that he was about to lose control over this woman who he had for 7 years. And I'm going to ask you all to bear with me for a few moments as I tell you and show you how we've proved this case beyond a reasonable doubt. Now, as Mr. McDermott was speaking, I'm reminded of 2 things. One, what I was told in law school, that when you have the law on your side, you argue the law. When you have the facts on your side, you argue the facts. When you have both, you argue both. And when you have nothing, you just argue, and argue. And that's what Mr. McDermott did for about 45 minutes. Now, I like Mr. McDermott, but he was given a tough case. And because of the case that he was given, he just had to argue to you for the last 45 minutes. And I'm going to show you how everything that he said makes no reasonable sense. Because what we ask you as jurors is that you have to make reasonable inferences based on your common sense and reason. We ask you not to leave your common sense at the door, but you bring it into the courtroom with you. And there's only one reasonable conclusion in this case. And all roads, all logical roads, all roads lead to one defendant, and that is him over there. I'm then reminded of a second story. A story that I've been told a long time ago regarding a red bike. And the story goes that there was a man coming across the border, and he had a red bike. And every day he would come cross the border with a red bike, but it had a basket with sand in it. And every day as he came across the border patrol guy would say, look in the basket and say, what's in here? There's something in here. Every day the guy would come and say, nope, there's nothing in there. Ride his bike every day, happened for a substantially long time. Then one day, the border patrol guy and the man on the bike was at a bar. The border patrol guy was getting ready to retire, and he speaks to the man and says, you know, all those days and all those years you were riding this bike across the border. And every day I looked, and there was nothing in the basket. What were you doing? God said nothing. Congratulations on your retirement. The night keeps on going, and they're drinking a little. And the border patrol goes and says, you know what, I'm a little drunk, I'm not going to remember what you tell me. But tell me what you were doing. He said, no, don't worry about it. Here's another drink. It's now the end of the night. Border patrol was like, look, I'm getting ready to go home. I've been drinking a lot. I'm not going to remember what you told me. Tell me what you've been doing. He said, you know what, I'm going to tell you. He said, you know, every day when I was coming through with the red bike, you were so focused on what was in the basket. But I was smuggling in a new red bike every single day. But because you were focused on what was in the basket, you were missing what was right in front of you. And what the defense counsel has asked you all to do is focus on all these reasonable theories, and we're going to talk about these reasonable theories in a moment, and not focus on the path that's right in front of you. And like I said to you before, the path that's right in front of you leads straight to Mr. Wolfenbarger. Straight. box the basket. Let's talk about it. First, no physical evidence. That's the first thing, right? We talked about the paint chips. Let's talk about when they went to the house. They went to the house in 2003. What happened in 2003? What do we know? Well, what we know from Dorothy is that he abruptly left in February, sometime in 1999. He didn't tell his friends he was leaving. He didn't tell Miss Dorothy, the person he would hang around with every day. He left all the clothes in the house. And what did Dorothy tell you? She had to come and clean it out. And then what did you hear? That it was remodeled. It was changed. So, of course, in 2003, when they go and do it, the paint chips don't match. Now, when it tells you, oh, well, the paint chips stay the same, you don't know what all the remodeling was in the house because it had changed. So there wouldn't be any paint chips that matched what was in her hair. Next, we talked about the bags that his DNA is not found on. But Mr. Fawcett talked to you about that. If we believe when the last time anyone besides him seen her, we know that in February of 1999, she didn't call her mother for her birthday. We know in March of 1999, she didn't appear for the court hearing for the battery case from July. So we know she's probably deceased, I would suspect, somewhere after Christmas of 98. Probably January or so of 99. So those bags were probably in that area for at least 3 months before they found them. People could be touching the bags, not realizing that it's a head in the bag, not realizing what's in it. They're picking it up, they're putting it away, whatever they're doing. There's other DNA on there. He already told you, because that's what he told Tina, what did she tell him? Tina, Miss Parent, all of them while they were sitting at the Waffle House, he know how to hide a body. Well, I suspect he know how to use some gloves to hide the body. Suspect he knows how to use some bleach. Remember someone said it looked like there was some liquid in the bags? See, you have to remember all of the evidence that came out. Well, he had the reciprocating saw, so we know he chopped up the body. Where's the torso at? But we're going to get to the torso in a moment. And he discarded it. So that's why his DNA wasn't on the bag. Let's talk about the blood, no blood after they moving off. Well, if she was strangled, there would be no blood. And is it reasonable he strangled her? Yes. You want to know why? Because her sister told you that she came in to the Waffle House in early of 1998 with strangulation marks on her neck. That's what she told you. So is it reasonable that he strangled her? Yes. So that's why there wouldn't be any blood. So that's why if they luminol, there wouldn't be there. Well, we know he strangled her. What do we know from Dorothy? He punched her. What do we know from the report? He dragged her. That's the way that he harmed her. There's no evidence that he used guns or knives. All of the evidence shows that he used his physical hands to hurt her. So is it reasonable that he strangled her? But it would be nice if we had her neck to really be able to tell you what he did. But see, they don't want to talk about that part of it. Let's talk about the pubic hairs. Well, what do we know? Thomas Dixon told you that they were intimate. What did he also tell you? The last time he saw her was in December of 1998. Could it be that the day that, remember when he said the last time I saw her, she left with him? So now you're pregnant, probably by the time this. You're left with him, so now I'm mad because you want to leave me. And I strangle you and kill you. You're right, that pubic hair could be Thomas Dixon. So the fact that there's no physical evidence doesn't mean it doesn't point to him, because there's a reasonable reason why there's no physical evidence. physical evidence. You know, they showed you the rain shower report. Well, the only month I see here is April. If she was died in January, February, or March, where's the rain report for those months? You have to start thinking about what they want to give you because they want you to go all over the place and not on the right path. Her body was sitting out there for months. She was severely decomposed. What did the ME say? I can't even tell you. It could be 30 days. It could be longer than that. I submit to you it was longer than that because her mother did not hear from her in February. Let's look at the evidence, y'all. And that is evidence. That's what came out on the stand. Because everything that came out on the stand is evidence. Stand in the box. Don't believe any of the state's witnesses about what you did. So everybody lying. Tina doesn't know Dorothy. Remember, because I asked her. Dorothy don't know Tina. But somehow they both saw Melissa with bruises. So they both lying? Why? What would they need to lie for? Matter of fact, Miss Dorothy, if you remember, if you watched her, when she came in here, she looked over at him. Because I guess she remembered seeing him from back in the day. And she kind of got a soft look on her face. And she tried to switch it up on him. If you can remember, because first I asked her, did you hear her yelling? She's like, I heard both of them yelling. And I said, is that what you told me and my investigator last week? And she's like, no, that's not what I said. And she changed the story. She wanted to help him. See, y'all gotta remember those little things. But then, as she was getting crossed, if you remember, she said at one point, I used to hear her scream. She said, I used to hear her scream. What did she tell you? That she heard it 3 to 4 times a week. Let's assume that they moved over to Brookline in January, February 1998. You know, we lawyers, I don't do a lot of math. But she 3 to 4 times a week. So say 4. So I'm good with that. 4 4 is 16. Times that by however many other months. How many times was she hearing this poor baby scream every week? But they want you to believe that no domestic violence was happening? You got to start thinking about the evidence, y'all. Because they didn't talk to you about that. Thomas Dixon, he don't know Dorothy. He don't know Tina. But somehow Melissa was able to tell him about what happened to her in July, but he come to here and he's lying too. Remember when he told you that I had been in prison for about 10 years and I saw her missing face on some cards. That's how he remembered that that's how he knew she had passed. And wanted to tell everyone about what she told him. And is that unreasonable? Because maybe he was her peace and solace to get away from him. You know, he asked questions about them being on the roof of the Waffle House. Maybe that was the only place she could get some peace, on the roof of the Waffle House. From him. What did, now I know she said all she would smoke take heroin every day, but what she tell you today? That when she called her friend, the last in 1998, he didn't want her to speak to anybody. So, we're supposed to disregard all of that. I submit you don't do that, because that's evidence. Now the Brocks. You know, he said, you know, I guess he claims that Ms. Brock told him on the phone that he returned the salt. He didn't play that interview for you. He played Wendy's interview. So where's that interview? The interview you heard is when the Brock said he borrowed the saw. Matter of fact, they corrected the police. The police said, you know, he stole the saw. They're like, no, he didn't steal the saw. He borrowed the saw. And they said on their own, and he never brought it back. And they told you that's not the reason why we fired him, but he never brought the saw back. And remember what we asked them earlier? In the culture of that job, they don't really ask what you use a saw for. They just use, they let their employees borrow the saw. That's evidence. Because how ironic is it that her body and the bones have lines from a reciprocating saw that he so happened to borrow from the job that he worked at. And it hasn't been returned. Ladies and gentlemen, this is evidence. And then, this whole thing that he was cooperative, he gave DNA samples, he did this. Well, he did those things because he believed he covered up the murder. He believed that he did what he needed to do to cover up the murder. But when it is time to now be held accountable, what is he doing? And we're going to see the video of that in a moment. He first sends his girlfriend out to say he's not home. So they skip over that part. When the police get there, she opens up the door, she comes out and says, he's not there. But what did O'Hare say? Because of the cell phone, they knew he was in the house. So he kept looking. And y'all saw the video, he looked. I think he thought he was behind that mirror. He kept on going back to that mirror. And then eventually he's like, no, he's here. And he knocks on that makeshift thing that he done cooked up himself in. But he's cooperative. This is going to, when I go through all their reasonable theories, the medical exam. What did she tell you? In her expert opinion, she did not die of natural causes. It was undetermined by highly likely homicidal violence. And what did she tell you? If we only had the torso. And why would we not have the torso? Could it be because she was pregnant? And he wanted to make sure that we never found that part of her. So you're going to get this instruction from the court, and this is what both Mr. Fawcett and Ms. McDermott discussed. You will be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories. Reasonable. Your duty, when you go back, a reasonable doubt, is a doubt of a fair-minded and partial juror honestly seeking the truth. It's not arbitrary, it's not vague. So let's talk about their reasonable theories. So the first one, a random person in the West End decided to kill her and decapitate her and cut off her legs. What evidence is there? There's no evidence. The only evidence of her walking down the street comes from the defendant, who has all reason to lie. We're going to talk about when he says this idea of her walking down the street. That she's hanging out with people who do drugs and alcohol. Who? Who? That's not reasonable. There's no evidence of it. Next is the male, they don't have his name, who molested her as a child. What evidence is it that he came from wherever he may live to come all the way to Atlanta to kill her, to use a saw to cut her, to put her in a bag, to discard her across the street from his job? What evidence? There's no evidence. It has to have some evidence behind it. Not just, oh, you think this in the world, not that it's a possibility. It has to be reasonable. And then Carl and Norma Patton. You know, when Mr. McDermott said, we're not saying it's Carl and Norma Patton, my mouth dropped. Every cross-examination was about what Norma and Carl did. That they had something happened in their living room. That Norma helped them in the living room. But what they didn't talk about is that Carl and Norma were looking for their baby when they didn't hear from her in February 1999. That they drove from their home in Stockbridge to go look for their child. That even when Mr. Patton got arrested in 2003, the first thing he wanted to do said, you got me? Go find the person who killed my child. That's what he said. Norma said, look, you got me? I'll testify against my husband. Find the person who killed my child. And they want you to believe that those are the two people who killed their daughter for what reason? Oh, now she wanted money. Most kids want money from their parents. I think I still ask my dad for money every day. That means he's going to kill me? Because I asked for money? Most parents want to take care of their children, protect their children. You have to make it make sense, and it doesn't. So criminals, we talked about this, but you get to decide who you believe. You know, when you have Miss Patton, Tina, look at their testimony in comparison to Kimberly, his sister, compared to Kathy, his mother. You can assess that. Why is it that Kimberly and Kathy can't remember a thing? Nothing. I don't know. You don't remember anything? Kimberly, that's your best friend. She was with you when you were driving on the road. And you don't remember anything about what she told you about your brother? But yet, Calhoun can come in here and tell you, you said that she wanted to leave your brother. She loved your brother, she wanted to leave him. She can't remember that. Why? Is it because remembering that will show that she wanted to leave your brother? And she don't want to be with your brother anymore? Mom can't remember that she never used to talk about Melissa to her grandkids? She can't remember if she went to go look for her or not? Why? But they don't want you to believe Norma and Tina, and Norma came in here and told you, this is what I did, this is what happened. She remembered everything that happened. She corrected us at times. But they want you to be so concerned about her past that you're not listening to what she's telling you right here today. I submit to you, don't fall down that path. Don't fall down that track. Your duty is to seek the truth, follow the law, and deliberate. If for some reason you want to back and one of your members say, I don't want to deliberate, they go hide in the bathroom, you come out and you shut the judge. You don't come out, but you should write it down and let the court know that one of your members is not deliberating. So let's talk about how we prove that he is. We don't have to prove motive. However, any evidence of motive is admitted for your use in determining the defendant's state of mind at the time of offense. This isn't a domestic violence case. This is a case of domestic violence. This defendant used his power and control from the time that she was 15. From the time that she was running out the house, from the time she was running away with him, he began to control her. What did Wendy say? She's easily controlled. She's a follower. That she's acceptable. She's gullible. And he knew that. She's stealing cars for him or with him. She's out here, leaving the house, trying to be with him. And the mom said, I didn't like the boy from the time I saw him at 15. Sometimes that's just a mother's intuition. Tension building. What did Dorothy tell you? The argument. That's tension building. The breaking of the glass. That's tension building. The incident. The marks on the neck. The incident. The July incident. The incident. The black eye that Dorothy saw. Those are all incidents. And those are what people saw. We know sometimes domestic violence happens in the house of things that people will never see. The reconciliation. Her wanting to go back to him. The TPO hearing where she drops the TPO.
Your Honor, we would approach.
Sure.
The TPO hearing. The reconciliation of it. That is evidence of a domestic violence relationship. And if there was a calm period, she went back. We know that he went to court with her, so those could have been times of that calming period. We talked about the different ways in which we exert power and control. So let's talk about some of the ways of exerting power and control. Isolation. What did we learn? When she got to Brookline, she didn't have any friends. What did Kimberly tell you? I started living my life. So we weren't friends anymore. What did Wendy tell you? They weren't friends anymore. What did her sisters tell you? That, we started hanging out again more and more once she started working at the Waffle House. So her connections weren't there. Her connections were down in Stockbridge. She was naive, easily influenced, believed what anyone tells her. We talked about the physical violence, using her children. I submit what happened in that room when the judge allowed them to talk is that he convinced her, give mom the kids. And she did. You give permanent custody permanent guardianship to my mother. And that is a form of control. Now your mother, the abuser's mother, now has her children, can dictate what the children do. We know that they didn't tell them about their mother. What did Ms. Jakes tell us about the role of a perpetrator? Plays the hero, the judge, and the victim. He's a hero when he's saving her from the house. A hero when he's taking her from the home, when she's running over to his support. He judged her when she wants to go back and be with her family, spend time with her family. Not allow her to talk to her family. And then when she finally decided she's tired and enough is enough, as she told Kimberly that I was done, he plays the victim. You can't leave me. Look what I've done for you. Look at how we are in my grandmother's home together. Look at how I saved you from your family, saved you from your trauma, saved you. You can't leave me. Abusive, we already talked about. He was controlling. his controlling behavior. Motive, pregnant by another man. Because remember Thomas said it, thought it was his. And leaving him for another man. And what did Rosa tell us? The most violent time for a victim of domestic violence is when she wants to leave. Is when she wants to leave. And she was leaving him. She found solace in Mr. Dixon. And he was going to lose control of her. That is why he killed her. She was going to leave him. She was leaving him. Now let's go through a timeline very quickly. Late 1997, early 1998. She goes to Waffle House crying with a bruise on her neck. Melissa indicates to her sister that Chris caused the mark on her neck. She initially tries to confront Christopher. Melissa doesn't want her to confront him. Troy instead hits Chris. Tina drops Melissa home and confronts Chris about hitting her sister. That's on 2 separate times. And then we know about the time at the Waffle House where he makes an ugly comment. He knows how to hide a dead body. January through March of 1998, Melissa moved to the grandparents' house on Brookline, again away from her family and friends. She's working at the Waffle House in Louisville. Remember? So, Melissa, March of 1998, Melissa visits her sister at Waffle House on Virginia Avenue and surprises her for her birthday. Remember when Tina testified, she said, I thought it was 99, but my mom did correct me and I realized it was 1998 and she remembered the wrestling people coming in and that's how she was able to remember the date. So it was 1998. And we know it's not 1999 because if you believe what her mother tells us, she did not call for the birthday and she did not appear for the court hearing in March. It's reasonable to believe she was deceased by then. Again, Melissa's still working at Waffle House in Doraville, and Christopher's not working at Action Glass yet. He didn't start until October. January through July, we talked about this. Dorothy hears arguing, sees Melissa with glass on her face and bruise under her eye. She saw Melissa with a baby maybe once or twice. You know about the July 21st APD police report. Melissa applies for a protective order. She seeks a petition to terminate guardianship on the 23rd. Temporary protective order hearing. Chris is allowed to speak with Melissa privately. That's when, after that meeting, is when Melissa asked for the TPO to be dropped. On the same day, she asked her mother to pick up the children from daycare and take them to Kathy Wolfenbarger and give permanent guardianship to Kathy Wolfenbarger. October 1998, Chris begins working at Action Glass. Melissa's probation court hearing, she tells the judge that she's pregnant. November 9, 1998, Norma sees Melissa at a court hearing. She leaves the court hearing with Chris. This is the last time that Norma sees her daughter. Thanksgiving 1998, Wendy Waddell calls Melissa. Chris does not allow her to use the phone. He's controlling Melissa's ability to speak to her friends. Melissa does not call her family on Thanksgiving. December 98, we know that Thomas sees Melissa at the Waffle House. He says to Chris, because he comes in, Melissa's crying, you can have her after 9 o'clock p.m. Chris waits outside. Melissa leaves with Chris. He never sees her again. According to the Wolfenbarger family, they see her at a family function in December of 1998. Again, her family does not hear from her. February 1999, she doesn't call her mother for her birthday. Carl Patton goes to Tina's job to inquire about Melissa's whereabouts. Christopher is fired from the job, but he had borrowed a reciprocating saw and had not returned. March 1999, Melissa is not present and cannot be located if in a battery trial. April 1999, her head recovered is unidentified. Other extremities recovered, unidentified. February 99 of January 2000, we know that Ms. Norma Patton is seeking assistance to locate Melissa, reaches out to several law enforcement agencies and receives no assistance. She speaks to a lawyer who puts her in touch with the Henry County Police Department. January, files the missing police report. Detective Scott assigned to the case. January 2000, Detective Scott does initial interviews with various family members to include or attempt to include Melissa's husband, the defendant. This is in January 2000. About 9 months later, he speaks to Christopher Wolfenbarger, and she is reluctant to speak to police or give police any contact information for Chris. 2001, he finally speaks to Chris, so it's 2.5 years after the remains are found, 18 months after the missing persons report, and 18 months before the remains are identified. And here's what he says. First, about her personality. These are his words.
Yeah, when we say that we're talking about, you got to understand, I don't know what all they told you about the mentality of her. She's not real, she didn't have a whole lot of street smarts at all. She was real smart, though. She had a lot of book smarts. She was real intelligent that way. But as far as, she was real naive, and I'm a little that way, but not quite like that. She would basically, if you could put an idea in her head and get her to thinking about it, she would swear that's right. And I guess that's why she had so much problems, running away and all the time. But she was a real follower.
He said, if you put an idea in her head, she will follow. She's a follower. That's how he did to control her. What did he say about her when she stayed with him? These are his words.
So she stayed with you for about a week, and then
she stayed with me
for a few days and stuff like that.
Sporadically, yeah. I'll say almost a month. I would say 3 weeks, because it was right around. It was almost Christmas, I remember.
So what does he say? She was sporadically with her until about December of 1998. No other person besides Chris sees her after December of 1990. What does he say? Because this idea that it's Norma who did this. In 2001, he says this about her mother.
But there's no way I believe that she ain't called her mama. That's the whole reason I ain't even, heard it.
He said, there's no reason why she wouldn't call her mom. I haven't been over there yet. In 2001, he figured she would be calling her mom. That's what he's telling the police. So why all of a sudden now is her mom could have killed her? And it corroborates what Norma said. She was concerned at Christmas when she didn't see Melissa, and she's even more concerned when she didn't hear from her on her birthday. So this is what you have to listen to. That he saw her in April of 1999.
And after she left, I didn't hear too much from her for, a couple months. I was like, whatever. But back in April the following year, which I guess would be 99, I seen her. And man, I was coming down Lee Street. I don't know if you know about the line like that, but it's right there, right where the train station is in the west end. I was coming out through there, and she was walking in the road, and me, just being a white girl, I was, blowing a horn because, we're a dying breed around there, But I stopped and I blew the horn at her, and I got down the road down by Krispy Kreme, turned around and come back. I'm like, I got thinking who it was, and I couldn't believe it, man. She just, I don't know, I guess, her sister could tell you how she looked. You got to picture how she looked when she was right.
Yeah, I got this on when that was done.
Yeah, see, that was before. That was like she looked like right after we got married. After that, man, she cut all her hair short, dyed it red. Started smoking. She looked totally different than that. But when I see her come back, man, she was real bad. She went off the gate and everything. I was like, man, I couldn't believe it. It broke my heart. But we stopped, and she said she wanted to talk, so I went up to Taco Bell. We ordered a little meal deal or whatever, And And at that time, she was like, I made a mistake. I want to come back home. And I was like, man, you don't know the emotional stuff, whatever it's going through for me, just like this.
So what? You said, I know it's my fault. When we finish this, you got to ask the county commissioners to give us assistance. But what he says is he saw her in April of '99 when he was driving down Lee Street in the West. And that she had bright red hair. And that she had track marks on her arm. Ladies and gentlemen, in April of 1999, her head was severely decomposed on April 29th. How is it that he saw her walking down the street and able to describe that she had short red hair? What did his mother and his sister say? The last time we saw her in December, her hair was down to here. But he sees her in April walking down the street. But she didn't call her mom. She hasn't called any of her family members. But yet he saw her and describes vividly. This is in 2001. This is before her body's identified. This is before anyone knows that the remains are hers. This is when he thought that no one would be able to find her. This is what he's telling the police in the missing persons report. And you have to remember that he abruptly leaves the neighborhood in early 1999. Why? That is your mother's home, your grandmother's home. Why would you need to leave that house abruptly? There's no reason except you had to get out that neighborhood. Let's see if this one works. But he tells them later on in that same interview again that he saw her in April of 1999.
I mean, she had taken she had dyed her hair several months before, but then right there towards the end, and especially when I see her in April, her hair was real short, real bright. It was like, it looked odd. It definitely stood out. I mean, she looked like nothing like that.
So he said she had dyed her hair a few months before. No one else has seen this except for him. He also says, and I'll try to play, but if it doesn't work, we'll keep moving, that she must have changed her name. Why would Melissa need to change her name? There would be no reason for her to change her name. Why? Again, this is in 2001. He wants people to think that she's moved away and just changed her name. She already wanted to leave him. She didn't want to be with him. She already started a relationship with someone else. So what reason would she need to change her name?
I know that she was, like I said, we was doing this. That's something I didn't think of. All right, I really don't know, but that's just my opinion. And she went through, because to this day, she still married me. I'm not, just now, I guess going through divorce, whatever, I'm trying to do all that. But
It's not, and I'll say this as a reminder, if there's any video that you would want to hear, you can do that if you're once you're deliberating. He also tells them in this same interview, you have to cut everyone off. Again, why would she need to do that? She had her family who loved her, her family who cared about her, her mother, her father who picked her up after the July 21st incident. There would be no need for her to cut anyone off. But again, he was trying to cover it up because, again, this is before anyone knows who she is.
I mean, she had taken she had dyed her hair several months.
In 2002, he files for and is granted divorce from Melissa. He also says in that 2001 interview that he's been working on the divorce since 2001. If you thought she just went away, you didn't think she was going to come back at all? Why are you filing for the divorce? You're filing because you know she's never coming back. March 18, 2003, Detective Scott and Calhoun meet with Chris. This is a few days after the remains are identified. If you remember, they kind of confirmed his story before telling him that she's been identified. And again, in this interview, he says the same thing. He saw her in March and April of 1999. Now he says he dropped her off at the train station, and that was it. She just disappeared in the night with no one else to see her. That story is a lie. And again, he's the last person to say he saw her.
The year she disappeared. I've been sitting here, I don't know if it's 98, 99. I know 2000, I was living in Savannah, so it can't be 2000. But whatever year that they're saying that they seen her, I know I seen her like in early March or April of the next year. And that was the last time I'd seen her.
That's November of 98 is when they're saying. That's Thanksgiving.
All right.
And then so end of the next year, 99, early 99, March, April, somewhere near when you think you ran into her. And he's probably more familiar with the area than I am, but he said that was Hornet. She was walking from like the Martin train station up from Brookline. Is that right?
Yeah, right there on Lee Street.
Y'all went to a Taco Bell in the area there and talked a little bit. And what happened? She walked off, rode away, and
I dropped her off at the train station.
so you were driving. What kind of vehicle you had at the time?
I had I want to say it's a tan colored Chevy Caprice, like a brown color. I mean, I can't be certain on that because I've got off of mini cars.
Then he says, he looked better than the last time he saw her. In 2001, she looked like she was doing something. He kept on saying track marks, but now in 2003, she looked better than the last time she saw her. I think I'm running out of time, so I'm going to speed through this pretty quickly.
What's the last?
This idea that she may have got a drug overdose, what he says is she was not on drugs while they were together. So this idea, he says.
When people do stuff like that, kind of just disappear from the family and just run, haphazard lifestyle like that, they're already on drugs. That's what I'm saying.
Oh yeah, she wasn't on nothing with us together. I'll say we smoke reefer every now and then, just where we go to concerts or something, or go out or something, might drink regular alcohol or something.
She went on drugs. So all of a sudden, the defense is, she may have had a drug overdose. He says it. And it's in 2003. He talks about the divorce being final. We don't need to play that clip. She wasn't afraid of her dad or anyone getting revenge.
Was she ever afraid either of him or somebody that, might be trying to get revenge?
No,
against him?
I don't know if she did. She never let on nothing like that.
She never acted that way.
No, she was always more quiet, or didn't.
So now all of a sudden somebody wants to get revenge on her? That's not what he said. She loved her.
I was just getting at how much you knew. Was she was ever afraid of him? She was afraid of her mom, but she couldn't stand her mom. I'm not really sure that's what, that's what's got me stomping out or whatever, because, it always seemed to me like, she loved her dad, with her dad, but her mom was always, every time she'd run away or whatever, she would come and tell me she was running away from her mom. I don't know, that's why I couldn't really say, I don't know, I just couldn't see him doing anything to her. I don't know, that's why I guess that's why I can't really think she'd be dead. Or it could be a homicide or whatever.
You can't see her. This is her dad doing anything. Now in May, you've heard this interview, so I won't play it. There's clips in here, but I'll highlight a few things for you. But this is the May 5th, 2021. This is now 18 years after the head and extremists have been identified, 6 years after media attention has been brought to the case. He talks about the last time he saw her. Now he doesn't really remember. And we understand that memory fades. But the defendant nor his family can remember a thing about this woman who's the mother of his child. And you heard it. You heard the interview already.
In view.
He thought she just left and moved on. Well, when she didn't come back, you didn't call the authorities. You didn't report her to anyone. This is the mother of your children. This is your wife. And you don't say anything? He never wanted to reach out to assist her own family, became worried. He didn't even want to speak to the police. Back in 2001. It took him 18 months to do this. Why?
When she would leave and go.
Now, all of a sudden, her parents killed her. In 2003, there's no way her dad could do it. But now that the media's been on it, now that it's been highlighted, now that the road is leading to him, he says her parents did it. And that's convenient. Let's blame the individual who was accused of accused of killing multiple people, and let's blame him.
What do you think happened to Morris?
2023, the police meeting with Christopher Wolfenbarger, and the investigation continues. And then here he is, hiding behind the wine rack in here. And he's hiding just like he told his daughter. When I have to go on the run, because that's what he told him, when I have to do it, I know where to go. You saw Christina here. She had no reason to make that up. And that's exactly what he did. Had a makeshift place to go hide. Now they said that we want you to do a legal logic. No, we don't. We want you to follow the path. Physical abuse in 98. Mom sees her last time in November of 98. She wants to leave him. He borrows a reciprocating assault and never returns it. She does not call her mother for the holidays. He does not appear for the March battery. She doesn't appear for the March battery trial. Carl Patton goes looking for his daughter. He abruptly leaves the neighborhood without telling anyone, leaving all of his clothes. Her head is found on April 29th, across from his job, severely decomposed. Extremities found in June, across from his job. He's the only person familiar with that neighborhood. His mom doesn't know where to go. What did Miss Patton say? The only time we went up there is when we went to go pick her up. They're not familiar with Atlanta. He is. Cut marks on her bones appear to be done by reciprocating assault, consistent with the type that he took from the job. Her torso never recovered. Could it be because she was pregnant? He never reports his wife missing. Reported missing by her mom in January. Mom's reluctant to give information. He lies to police in September. Never speaks to his children about their mother. Body parts found in ATL. No other family resides here. This is where everything is found. From the house to his job to the location of the police. This is not illegal logic. We're not asking you to jump. We're asking you to follow the path. And all the evidence leads to one conclusion. He's guilty. Now, ladies and gentlemen, we might not have all the puzzles. We wish we had her torso. He was clever enough not to leave DNA. But what we do have is this. You can still see this dollar bill, even with all of the missing pieces. You still see that the path leads to only one person. Only one conclusion. Now, sometimes things are challenging. And this is going to be hard for you all to see. But this young lady right here should not have lady deserves to have raised her children. This young lady deserved to have lived a life. This lady deserved to have continued to work, to be a part of her children's lives, her grandchildren's lives, but she is not. The defense has operated on what if this, what if these possibilities, what if. We want you to focus on what evidence came out of the trial, what the reasonable conclusion is, and you will not be telling him something he doesn't already know. For 27 years, he's known what he has done. For 27 years, he has sat and hid from justice. We are imploring you, we are asking you, don't listen to these fabricated stories for what the defense is telling you. When you follow the truth, when you seek the truth, there is only one true result. That this defendant, Mr. Wolfenbarger, is guilty of murder. And we're going to ask that you do that. Evil prevails when the men and women fail to act. I'm asking you to act. We are asking you to act. And we are asking you to find him guilty. Thank you.
Thank you. Ladies and gentlemen, I'm going to, in a moment, just give you the charge of the court, which is that law that I promised when I first swore you in to be jurors in this case. And I, too, have a PowerPoint. And mostly I do that so that people process things differently. And so some people hear things better and understand it by hearing it. Some people, it's helpful for them to see it. You will have a copy of these jury instructions with you in the jury room while you deliberate.
Thank you.
Ladies and gentlemen, you are considering the case of the state of Georgia versus Christopher Wolfenbarger. Now, the lawyers have referred to some of the governing rules of law in their arguments, and if there is any difference in the law that was stated by the lawyers and as stated in these instructions, you are governed by these instructions. Nothing I say in these instructions indicates that I have any opinion about the facts. You, not I, have the duty to determine the facts. You must perform your duty as jurors without bias or prejudice to any party. The law does not permit you to be controlled by sympathy, prejudice, or public opinion. All parties expect that you will carefully and impartially consider all the evidence, follow the law as it is now being given to you, and reach a just verdict, regardless of the consequences. Excuse me. You have been selected and sworn to try the criminal case of the state of Georgia versus Christopher Wolfenbarger. The Fulton County Grand Jury has indicted Christopher Wolfenbarger for murder. I will now read you that indictment. In the state of Georgia, in the county of Fulton, in the Superior Court of said county, the grand jurors selected, chosen, and sworn for the county of Fulton, in the name and behalf of the citizens of Georgia, do charge and accuse Christopher Wolfenbarger with the offense of murder. For the said accused in the county of Fulton in the state of Georgia, sometime between the 10th day of December 1998 and the 29th day of April 1999, exact date being unknown to the grand jurors at this time, did unlawfully and with malice aforethought caused the death of Melissa Dawn Wolfenbarger, a human being, by inflicting homicidal violence upon her in a manner unknown to the grand jurors at this time, contrary to the laws of said state, the good order, peace, and dignity thereof. Ladies and gentlemen, you will have the indictment with you in the jury room, along with a copy of these instructions and a verdict form. The defendant has pleaded not guilty to this indictment, and he denies every charge in it. This indictment and the defendant's plea of not guilty present the issue that you have been selected and sworn to decide. The indictment is the way the defendant is charged with committing crimes that violate the laws of Georgia. The charge in the indictment and the plea of not guilty are not evidence of guilt, and you may not conclude that the defendant is guilty based on the charge or the not guilty plea. The defendant is presumed to be innocent until he is proven guilty. The defendant begins the trial with a presumption of innocence in his favor, and this presumption stays with him until it is overcome by the state with evidence that convinces you beyond a reasonable doubt that the defendant is guilty of the crime charged. You may not convict the defendant of any crime unless each element of the crime is proved beyond a reasonable doubt. The burden of proof is on the state to prove every essential element of the crimes charged in the indictment beyond a reasonable doubt. The defendant has no burden of proof at all, and the burden never shifts to the defendant to prove his innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the defendant beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is a doubt based on common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which you can give a reason based on the consideration of the evidence or lack of evidence, a conflict in the evidence, or any combination of these. After considering all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must find the defendant not guilty. But if no reasonable doubt exists in your minds about the defendant's guilt, then you may convict the defendant. If the state does not prove the defendant's guilt beyond a reasonable doubt, your duty would be to find the defendant not guilty. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented, and then you must apply the law that I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is how a fact is proved or disproved. Evidence can be either testimony or exhibits. Testimony is what you hear from people who take the witness stand and swear to tell the truth. However, the questions the lawyers ask the witnesses are not evidence. Exhibits are documents, photographs, or other physical items that are admitted during trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or the questions asked by the attorneys. Evidence may be either direct or circumstantial or both.
Considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts or circumstances that tend to prove or disprove another fact by inference. That is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight that you may give to
either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. In determining the credibility of a witness, you may consider evidence offered to attack, challenge, or cast doubt on the witness's credibility. This may include evidence of criminal convictions as shown by proof that the witness has been convicted of the offense of a felony or a crime of dishonesty. Your assessment of a witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. A defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, a defendant does not have to present any evidence or testify. And when a defendant chooses not to testify, you may not consider that in any way in making your decision. You have received evidence of prior convictions of witnesses who testified in this case. You may consider this evidence only insofar as it may relate to attacking the credibility of the witness and not for any other purpose. It is for you to say whether under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify a defendant beyond a reasonable doubt as the perpetrator of the alleged crime. It is not necessary that a defendant show that another person committed the alleged offense. If you do not believe that a defendant has been sufficiently identified as the person who committed the alleged crime, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of a defendant as the person who committed the crime alleged in this bill of indictment. Defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act or omission to act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. A defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. A person commits malice murder when that person causes the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification, excuse, or mitigation. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. The law provides that criminal actions shall be tried in the county in which the crime was committed. Venue, that is, the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt, as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence, or both. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County, Georgia, did commit the offense as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of the offense, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of the case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of any defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual orientation, local or remote residence, or economic status for or against either party. You are only concerned with the guilt or innocence of this defendant. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case
with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messages, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed by all. The verdict must be signed in ink by one of your members as foreperson, dated, and returned to be published in open court. The alternate jurors are jurors 43 and 45. You will be given separate instructions by the deputy. You may now retire to the jury room, but do not begin your deliberations until you receive the indictment and any evidence which has been admitted in this case. If you have any questions during your deliberations, please write them out and give them to the deputy. If you wish to take a break during your deliberations, please notify the deputy. But please understand that you may deliberate only when all of you are together as a group in the jury room. Deputy, please escort the jury to the jury room. And ladies and gentlemen, your lunch is there and ready for you. Thank you all. The jury is clear. You may be seated. Any objection to the charge as I gave it from the state?
No, Your Honor.
From the defense?
The objections are the ones that we announced before. Are we preserved, or you want me to reiterate what they are? It was the...
As far as I'm concerned, they are preserved, Mr. Samuel. The objections that you already asserted, you had preserved them when I said this is the charge I intend to give. You indicated that you continue to object, and I've, of course, now given them, so you can object again.
You want me to object again? Okay, the 404B instructions we requested.
Yes, sir.
There were 2 or 3 of those. And the prior difficulties instruction, we think both of which were necessary in this case.
Okay. I do, forgive me for interrupting, I do want to make a note. There was an objection during the closing argument, the second part of the state's closing argument, as to Ms. Hylton. The parties approached. I notified the parties that I would make a note of it and make a record of that objection. The objection was to I think it was a statement by the state regarding actions by Melissa Wolfenbarger in stealing cars, and that somehow that was with or for Christopher Wolfenbarger, I think was what I understood. The discussion that was had at the bench was, number one, that's 404B evidence that was never, that was not appropriate and would not have been admissible, but also I had not heard any evidence about Mr. Wolfenbarger's connection to those alleged car thefts by Ms. Wolfenbarger until that moment. In any event, the objection was preserved, and the party stepped back and the state agreed to move on from that issue rather than highlighting it by withdrawing it. Anything else you want to put on the record regarding that issue, Mr. McDermott?
No, Your Honor.
Ms. Hylton?
No, Your Honor.
Anything else from the defense, Mr. Samuel? I interrupted you, sorry.
You didn't interrupt me.
Okay.
Thank you.
Okay, so can y'all please make sure that y'all have all the evidence together, and that to get it ready to go back to the jury? Deputy, my understanding is that the alternates, Judge Williams has graciously agreed to loan us her jury room for the alternates.
Yes.
So you can, once they get their lunch, you can, and it's time for these jurors to deliberate, and we can take them over there.
Yes, Your Honor.
Okay? If y'all can check and get the exhibits together.